All right, court is going to call 2022 CR 3745, State of Texas versus Joseph Dale Harris. Can our parties announce for the record for the state?
Jason Garahan, Daniel Escobar.
For the defense?
Cornelius Cox.
And are you Mr. Harris? All right, you may be seated. All right, yesterday there was a question by the defense whether or not the complainant had ever been committed to a state hospital. Is that correct, defense?
That's correct.
And neither party objected to the court trying to discover this information because the defense had sought to discover the information but was unable to. After research by the court, which no party had any objection to the court trying to research the matter, the court received information that the defendant had not been committed in the state hospital. Is that correct, defense?
I think you said defendant, Judge, but I think...
I'm sorry, the complainant had not been committed to the state hospital. Is that correct, defense?
We agree that information was made available to in the court.
And that was the information that was made available to the court?
That's correct.
All right, and defense, do you have any information contrary to that?
Not contrary to that. Our position was always that there was evidence suggesting that the complainant had been hospitalized at the state hospital. In terms of the nature and exactly how that came about, we did not have the opportunity to develop that issue.
All right, and the court will note for the record again, according to the court's docketing sheet, that this case has been here with regards to discovery since July 11, 2022. Court will note that the medical records issued were on the court's docket since December 19, 2022.
And if I may respond to that, those medical records that the court is referring to is the hospital records that were conceived when the complainant was when there was attempt to try to substitute him or try to say those the court is talking about records. In terms of any type of mental health record, that information was never provided to by the state.
All right, and defense, with regards to that information, it's the court's understanding that on body camera and in the prosecution guide, it stated that allegedly the complainant may or may not have been acting erratically. Is that correct?
That's correct.
And when did the defense have the prosecution guide?
Early in the, at least by the time of this case was actually indicted.
All right, and so that would have been in 2022 at least?
Yes, sir.
All right, and when did the defense attempt to subpoena the mental health records?
I believe that was the mid-August of this year. That's when we attempted to subpoena those records. And the basis of that was not because of anything that their position was always, we don't know anything about mental health. My position is that wasn't true. I won't say it wasn't true, but it was not exactly the circumstance.
The court will note for the record that this case has been on the court's docket since July 11, 2022. The court will note for the record that the defense was aware of, or should have been aware of, any type of mental health issues since July 11, 2022. The court will note for the record that the defense did have mental health medical records subpoenaed in regards to the complainant, and the defense received some of those records. Both the defense and the state asked and had no objection to the court attempting or seeing if the court could discover whether or not the complainant was actually committed to the state hospital, which it was the court's understanding, and which the defense stated that the defense wanted to know whether or not the complainant had ever been committed to the state hospital. And based upon the information that the court has received, which both the defense and the state were made aware of, there has been no civil commitment of the complainant to the state hospital. All right, is there anything else?
And just briefly, Judge, our position is, the defense position is that those records, that mental health issue, our position is that is consistent with Brady. Our position is that for the state to either ignore those issues or not to specifically provide those issues or whatever information they may have in that line is a direct violation of Brady.
State.
Judge, just to respond to that last statement by the defendant, these records have been and are currently still not in possession of the state. And I notified defense counsel Cornelius Cox of that several months ago and mentioned that we did not have these in our possession, nor were they in our possession. So just wanted to put that on the record to make it clear that the state has not been hiding or obtaining records and not turning them over. to defense. Everything in the possession of the state has been turned over to defense for this trial and for this case.
And the records you're speaking of are the mental health records of the complainant?
That is correct.
All right. All right. Deputy Laura, can you see if the jurors are here? All right. So we will wait for those 3 jurors. All right. We'll go off the record. Eric Diaz. Is he in custody? All right, come forward. Good morning. All right. So he's scheduled for jury trial?
I had subpoenaed records a little less than a week ago.
All right. Mr. Diaz, we'll see you tomorrow for jury trial. Ms. Ferguson will give you a reset form. All right, you're welcome. And counsel, if you're requesting a continuance, you'll need to file a motion. Jesse Inaho, good morning. How are you doing? Oh, I'm doing great. All right, we're scheduled for jury trial. All right. Mr. Inaho, we'll see you tomorrow for jury trial. Ms. Ferguson, if you'll give them a reset form.
Just so the court's here.
Oh, we'll wait for you. And tell Judge Fulliam I said hello. Thank you. Delmison 3. All right. Who's here on John Carlos Cisneros Armstrong? Oh, just have a seat. We'll wait for your attorney. And then Carlos Madrigal Hernandez.
That's Mr. Hernandez, sir.
And then Mr. DeLeon. Your person is Nieves Carrillo,
Yes, Your Honor.
and he's in custody.
She is in custody.
Can you bring her out, Deputy Mejia? Thank you. Oh, she's not on the docket? Oh, Deputy Mejia, she's not on the docket. So if you go back there to search, she will not be there. All right, so what are you requesting for this? All right, so what we'll need is we'll need to have them present, and we'll make that happen. So just get with Miss Ferguson to see if she can put it on the docket this week. Yes. Well, I like to hunt for which room you're in. All right, and they're all here. All right, everyone, the jurors are here. And each side will have 30 minutes for argument. How do you all want your time broken down, State?
Your Honor, I just would like a 5-minute word rundown. You can give me a 5-minute warning when 5 minutes have expired.
Okay. Defense?
We're gonna do 15 minutes. We're at 2 minutes.
All right. All right. So we're going to go on the record. In 2022 CR 3745, State of Texas versus Joseph Dale Harris. Again, could I have parties announced? Excuse me, counsel, you need to move. Could I have parties announced?
Jason Garrett, Daniel Escobar.
Defense?
Cornelius Koch and Lorraine Efron.
And are you Mr. Harris?
Yes, ma'am.
All right. Have both parties had a chance to review the charge of the court or the jury charge, State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right. Any objections to the jury charge, State?
Your Honor, the only, we'd like to put on the record that we were asking for the paragraph 4 on page 5, which speaks about apparent dangers, could be removed off the record. I believe you had already ruled on that it is going to stay, that the state's just subjected to that.
All right. Thank you. Defense, any objections?
No objection.
All right. Let's bring the jury in.
All rise for the jury.
And everyone, please make sure your phones are silent. There is nothing worse when people are doing arguments and the phone goes off. If your phone goes off, just leave the courtroom and wait outside. All right, everyone, please be seated. All right, defense, call your next witness.
During this time, the defense.
State,
It moves to close, Your Honor.
defense, do you close? All right, thank you. All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case during this phase. What I'm going to do is I'm going to read to you what's called the charge of the court. You do not have to memorize it. A copy, well, not a copy, the original will be given to you to review. All right. Charge of the court. Members of the jury, the defendant, Joseph Dale Harris, stands charged by indictment with the offense of murder alleged to have been committed on or about the 28th day of February 2022 in Bexar County, Texas. The defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2. Individual means a human being who is alive. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 28th day of February 2022 in Bexar County, Texas, the defendant, Joseph Dale Harris, did intentionally or knowingly cause the death of an individual, namely Isaiah Orozco, by shooting Isaiah Orozco with a deadly weapon, namely a firearm, or the defendant, Joseph Dale Orozco, with intent to cause serious bodily injury to an individual, namely Isaiah Orozco, did commit an act clearly dangerous to human life that caused the death of Isaiah Orozco by shooting Isaiah Orozco with a deadly weapon, namely a firearm, then you will next consider whether Joseph Dale Harris acted in self-defense or in defense of a third person or persons, and proceed to paragraph 5. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Joseph Dale Harris, not guilty and do not consider paragraph 5. 5. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from the standpoint at the time. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit murder, and 2, the defendant did not provoke the person against whom the force was used, and 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. Have a seat. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. Defense of a third person. A person is justified in using deadly force against another to protect a third person or persons if, 1, under the circumstances as he reasonably believes them to be, the actor would be justified under the law of self-defense as instructed above in using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person or persons he seeks to protect. And 2, the actor reasonably believes that his intervention is immediately necessary to protect the third person or persons. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person or persons. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Now, keeping in mind these instructions regarding self-defense, or persons, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the charged offense of murder, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, and 2, Joseph Dale Harris reasonably believed, assumed to have reasonably believed, as viewed from his standpoint, his use were immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force. And 3, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Joseph Dale Harris, and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that 1, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, or 2, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force, or 3, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense, but next consider whether the defendant acted in defense of a third person or persons as instructed below. Defense of a third party application. Keeping in mind the instructions above, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons, and 2, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect the third person or persons against Isaiah Orozco's use or attempted use of unlawfully deadly force, and 3, Joseph Dale Harris reasonably believed or is presumed to have reason to believe, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons, and 4, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Joseph Dale Harris, acted in defense of a third person or persons and acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that 1, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons, or 2, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect a third person or persons against Isaiah Orozco's use or attempted use of unlawful deadly force, or 3, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons, or 4, Joseph Dale Harris' use of deadly force was in response to provocation. 4, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone, then you will find against the defendant, Joseph Dale Harris, on his plea of defense of a third person or persons and find him guilty of the offense of murder as charged in the indictment. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of the fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, or after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them. them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may begin.
I quickly wanted to cover with you a few things that are in that jury charge. First thing I wanted to say is that you are going to get the jury charge during deliberation. You don't need to memorize anything that I have to say. The first, as Jason mentioned in voir dire, is that there are 2 paragraphs to a murder charge. Now, it doesn't need to be unanimous agreement as to which paragraph applies. If 6 of you say paragraph A and 6 of you paragraph B, that's enough. Go over it. Paragraph A. We've proven the date, February 28th, 2022. Many witnesses came forward and say that was the day that this happened. Bexar County, Texas. This happened a few blocks away from the court. Happened in Bexar County. The defendant, Joseph Harris. Multiple people said that the same person that the police ended up apprehending was the same person who shot. And Joseph Harris admitted to the detective that he was the one who fired his weapon. That's not in dispute. Intentionally or knowingly caused the death of Isaiah Orozco by shooting it with a deadly weapon, namely a firearm. None of that is in doubt. Isaiah died as a result of his injury. The defendant shot at him 16 times, intended to kill him. Now, many of the elements in paragraph B are similar or the same. Again, the date, Bexar County, the defendant. The main difference is intent to cause serious bodily injury by committing an act clearly dangerous to human life that resulted in the death of Isaiah Orozco. Again, he shot at Isaiah 16 times. He intended to cause serious bodily injury, and it caused Isaiah's death. Either way, the state has proven each of these elements beyond a reasonable doubt. As it said in the jury charge, you will not be getting any police reports that have been mentioned in this trial. Many of them have been brought up. You cannot let bias or sympathy play a role in your determination. You must look at the facts and what's been presented. It has met its burden. We've shown overwhelming evidence here. We ask that you find the defendant guilty, that the state reserves all remaining time.
All right, defense, are you prepared?
Yes, Your Honor. I was in fear. I was in fear for my life. That's what you heard Mr. Harris say. He was in fear for his life. The state has to prove each and every element beyond a reasonable doubt. They have to prove he did not act in self-defense. They have to prove he did not act in defense of a third person. They have to prove he did not act reasonably. All of those things are presumptions in favor of the defendant. The presumption of innocence alone is enough to say not guilty. Here we have, I was in fear for my life. And we have, stop texting me, stop texting me, stay off my block, stay off my block. But he's not saying these words and pulling out his cell phone, stop texting me. No, he's saying these words and flashing his gun, pulling his gun out, right? You are supposed to view this in the eyes of Mr. Harris. Did a reasonable person standing from the viewpoint of Mr. Harris? No, in this case, you've heard a lot of different viewpoints here, right? We hear from this building, that building, here, and the bus, and there's a whole lot of vantage points that you heard from. But the one that matters is Mr. Harris, and he told you what he observed from where he was standing. He sees a gun, he hears crazy talk. What did you hear the witnesses say today or over this last week? His words were confusing. They did not make sense. They were loud. They were confrontational. They were threatening, erratic, mental, belligerent. You heard witnesses say those things. Mental, belligerent, loud, erratic. And he had a gun. And his cell phone's not in evidence. His gun is. I was in fear. I was in fear for my life. Witness says, you saved lives today. They thought you saved lives today. You saved lives today. That's uncontroverted that was said to him. Mr. Harris says, I was in fear. I was in fear for my life. And what does he do? He stands there. He says, call the police, call 911. He did not hide. He did not evade. He did not resist. He stood there. He waited. He asked people to please call the police, call 911, and he waited. And what did he do when the police arrived? He cooperated. He said, I did it. I did it. That's a person who acted in self-defense. That's not a person who has something to hide and is trying to run and hide behind a corner. I mean, this was a busy downtown street and block, right? A lot of buildings around and lots of people around. And that's what you saw from all the pictures and videos. One thing that is over, you see in all of that is all the people that are around, right? And that you can are around, because it's not, you don't see a 360 view, right? You see trees, you see shadows, you see a whole lot going on, you see city noise, people are hearing and seeing different things from where they stand. But from where Mr. Harris stood, not only several witnesses said he was stop texting me. No one said he had his phone. Stop texting me. No one understood who was texting him. Who was texting him? Was he getting it from a street lamp to his head? We don't know. We don't know if he was getting any actual text messages that day. But we know he was receiving them in some way because he was complaining and he said, stay off my block, stop texting me, here's my gun. The law of self-defense is that a person that a person that reasonably believes that the force is necessary to protect himself. Reasonable belief is a belief that would be held by an ordinary and prudent person in the same circumstance as defendant. It's not any reasonable person. It is a reasonable person standing in Mr. Harris's shoes. I was with my buddy. I was catching the bus. It was my daughter's birthday. I hear this guy. It's so unusual. I hear him. I see him walking around the block. I don't know what's going on with him. And then he starts flashing the way. He doesn't have a duty to retreat. He does not have a duty to retreat. He has a gun. He's in fear for his life, and he has the ability to do something about it. He saved his life. He saved others' lives. And the presumption of reasonableness to Mr. Harris. The presumption of reasonableness goes to him. The state must prove to you he did not act reasonable, and the state cannot prove that because he didn't. He has the right to respond to real danger and apparent danger. A gun is a loaded gun. Does anyone dispute that? You see a gun, what else is it but loaded? You might be able to clear it and put a zip tie on it later and hey, it's cleared, it's all safe. But on the street, it's being displayed with some crazy talk. A gun is a loaded gun. That's real danger, it's apparent danger, and it's no other. The state can't prove otherwise. The state must prove that Mr. Harris, did not act in self-defense. They have not proven that he did not act in self-defense because he did. He has a right to defend himself from apparent danger, and he did. Mr. Harris gets the presumption of innocence here. Mr. Harris responded in fear. There was not a moment in time where you have, time to analyze whatever. It is happening now, and you have to act. Your life or someone else's. You're going to save your life and the lives of others. You must act, right? And that's what he did. He was in fear. He was in fear for my life. That's what he told you. I was in fear for my life. I was trying to make it to my daughter's birthday party. I didn't want to die that day. I did not want to die that day. And this guy was talking crazy talk and flashing a gun. I didn't know what was up. He was erratic, bizarre. He had a gun. It was a busy street with lots of people around. And I did the only thing I could do. Save myself and save the lives of those around me.
Defense.
May it please the court, attorneys for the state, members of the jury. This part of the trial is called or known as summation closing argument. And basically, this is the time where the warriors have an opportunity to speak to you to highlight what we feel that the evidence in this case shows. It's important for you to know that what the warriors say, it's not that. It was a week ago. You all started a journey. Because in this room, we selected this jury with the responsibility of determining whether the state proven its case beyond a reasonable doubt. You promised by your oath you would hold the state to that burden. And if they fail, notwithstanding perhaps their good intentions, if they fail to meet that burden by your verdict, you must be accused. We only have one opportunity to speak, and the state has second option. So when I'm seated, they can come up and they can say things, and I can't rebut. So I need to kind of address what they said already and anticipate what they may say when I'm seated and I can't say anything beyond a reasonable doubt. But first, we thank you for your patience. We thank you for your attentiveness, and we thank you for meeting the challenge, analyze the state, coming forth with a verdict. Sometimes in trial like this, what the state is going to do properly is they'll probably show you the video. They may show you the photograph and tell you that there's only one verdict that you must render in this case, because when they show you the photographs, they may show you the weapon and tell you that case kind of cries out, you need to go back into the jury room and verdict. Now, I feel that your job is more profound than that. They may, the state, and sometimes they'll pound to death. They may point at the accused, paint him as a person that's not reasonable, that acted, beyond reasonableness, and you should convict. But as you think about the evidence in this case, as you go through section, or sometimes you may decide to take each one's testimony. The question probably is why. It's correct. February 28, 2022 was the day of this event. My client was a typical death. The evidence in this case shows that morning he had no shooting anybody after defending himself. The only thing that he was considering was catching a via bus and preparing for his 2-year-old daughter's birthday. Question, why? Why does he find himself here today? Typical morning, daughter's birthday preparation. What you know is that meets an acquaintance, and they're both going to catch the bus, and they having small talk. Nothing at that point in his life, an experience that's going to put him in this chair. And what happens? He sees a person we know at this point is the complaint. He seizes, and at this point, Mr. Harris is minding his own business. All of a sudden, he's just yelled by this person. For some reason, there's a fixation, my client and his friend. Why the fixation on those yelling about why are you on my block, or this is my block? He's seated on the bus, minding his own affair, and all of a sudden, why are you on tapping to anybody? Why are you on my block? He's waiting to catch the bus. Then why are you texting? Where does that come from? So in terms of what's, and you heard Mr. Harris testify, in terms of what's going on, you're trying to, in real time, I would imagine, trying to get an understanding of what's going on. And there's an escalation. Now, the state is probably going to say, well, my client, he escalated the situation. No, where the escalation comes from is that the complainant at this point reveals that he has a firearm, not a cell phone, not a fan to cool yourself. He has a firearm. So you compound what he's saying, the erratic behavior, and now the person exhibit a firearm. Co-counsel was right. So what do? Is not a situation you see even in this courtroom. Firearms that were displayed, and is always concerned, even in a controlled environment, to make absolutely sure that they weren't active or low. You're on the street, minding your own business. Somebody approaches and they got a firearm. I submit to you that when the state comes before you and they want to show you the picture, let them explain the justification for the complainant to exhibit and be aggressive with the firearm. Why? That's why and what's the testimony after that? Mr. Harris, he approached his hands, a testimony is not. He had his hands up. Wanting to what? He escalated. He has his hands. And the law says, if you look in the charge, my client, in terms of self-defense, he's in a lawfully. There's nothing wrong with being in a location. He's not doing anything illegally. He got hands up and he's not approaching people. And the reason for that is that he wants to escalate. And like I said, they may show you the video over again and over again. They may stop. They'll probably try to suggest to you this person that's speaking erratically, and because that person appears to kind of like turn a little bit, danger is over. They may even suggest that because the crime scene technician indicated that there wasn't actually a bullet in the chamber of the complainant, that he was harmless. Remember when I asked the witness that how long would he interact with the weapon? And we started at 5 minutes, 3 minutes, 4 minutes. We got down to say maybe a second. And we didn't talk about distance, even from where he was, even if he backed away, the complaint, he still fired a shot. He had enough in his weapon to kill or hurt a lot of folks. Why? Ryan only wanted spend time with his 2-year-old daughter. He wasn't able, citizen or resident of San Antonio, Bexar County, and he only wanted to sit on a bus for a bus to his family. Detective detective. And what is the lead detective? It's my job to make the case, get all the information and decide or not make it. And there were discussions she talked about. We never heard whether there was any evidence whatsoever. And the officer testified that they had my client phone that he or anybody else was texting the complaint. What was the fixation? I asked the detective, lead detective, I said, well, there were, 50, 60 police officers involved in this case. Did you suggest to anybody or yourself to go out and see if you can get other video from other buses in the area that leads up to what happened? The officer says no. The detective said, why? Because they were fixated just on the shooting. Not about what happened prior to the burden that the state had. And we talked about it during jury selection. Proof beyond a reasonable doubt. And that burden does not change. I submit to you, this is a case, self-defense, classic case. You don't have to wait until somebody acting a rat shoots a lot of people before you acted that day. His actions were, from his vantage point, reasonable. And I submit to you, the only just that goes along with the evidence in this case, and no matter how many times they may come and try to point and hit the table, the only just verdict in this case is a verdict of not guilty.
All right, State, are you prepared to proceed?
All right, ladies and gentlemen, I'll be the last person to talk to you today. We're going to start deliberating in the back. And not opposed to beating on tables or desks or anything, but I think the facts sort of speak for themselves. You've seen the video numerous times. And yes, I'm going to show the video again in a little bit because we don't get videos like that. Defense counsel said this is classic self-defense. Classic. Read that jury trial. I asked each to come back in here with a not guilty. This self-defense. I'll tell you that Officer Robler arrived at the scene just on his body-worn camera. That's how he saw Mr. Isaiah Orozco laying there on his side, headphones near his head, defendant down the road on the sidewalk, saying he's the one that shot. Because as Mr. Escobar, my co-counsel, stated, the elements are not in question. The defendant admitted to shooting him. Happened here in Bexar County on February 28th. We want to do something about came ago because as defense counsel went over the self-defense claim, that's what we're going to vote because that's what they're claiming, that this was classic self-defense. As we go through the witnesses, Mr. McDowell, Michael McDowell, you believe him? As he stated.
Excuse me, just 1 minute. I'm going to pause you. Deputy, please let her remain outside. All right, you may resume.
Ladies and gentlemen, Mr. McDowell, I don't think he has a bone in his body. He's very credible. He stated that the individual, Isaiah Orozco, the complaint was not angry. He was just telling him, stay off my block, stop texting. Go on to other individuals like William Fowler. You could tell from the way he testified that was a very emotional day for him. The witness, somebody being hunted down, chased, shot right in front of him numerous times. The last shot going to the head and seeing what he said looked like confetti coming out of his head, parts of his body flying off his head. That's that last shot. We heard from Gonzalo Salinas that stated that he had a vantage point at 3 stories up. As he looked outside after he heard shots, he saw this man over here walk up to the victim, up to Isaiah Orozco and shoot it. There's that pause in the action, pause in the act. The kill shot, the shot to the head is what killed this man, no doubt. The fact is, that was the last shot. Numerous testimony from numerous witness men saying that man over there chose to do that to that man. Self-defense, classic self-defense. You had Julio Zamora. He heard the shots, he heard that pause, and then the last shot. As he looked out the window, he saw this man walking back to the bus stop by that wall and giving a fist bump. Classic self-defense. You heard from the defendant. You saw his state. Compare that statement to what he testified to on the stand. It's fuzzy when he was giving his statement, supposedly. Couldn't remember exactly. Hours after, he was fuzzy. Couldn't remember. Well, you know another thing about that is he never saw that video until after. He didn't see that video that day. So he was able to make up a story because if you go back to that statement, he states there's no videos. There's no way there's a video. It's too quick. By the grace of God, a Via bus pulled up. He didn't know that Via bus had those cameras on there. That's why his statement, when he gave it to the police, was much different than when he got up on the stand and testified to you the other day. He had to correct his story. He had to lie. He had to be fuzzy memory then. You'll look in that video and you'll see Isaiah Orozco keep on turning around. That's not in the video. You don't see him pulling up his shirt over and over as the defendant gave his statement. You will not see him turn around. You will not see him pull up his shirt. You won't see him display the gun more than that one time, and he puts it down. Now, let's talk about self-defense. Justification for Isaiah Orozco to display his gun. I'm going to tell you this. We're never going to know the motive between these two individuals. We're never going to know the history of it. Defense counsel kept on asking why. I told you in voir dire, motive is not an element. So that's off to the side. The why doesn't matter. That's motive. So when we discuss about justifications, defenses to this type of crime, let's talk about Isaiah Orozco. He's having some type of argument, some type of discussion discussion, probably heated, with this individual. Maybe not this individual, maybe Jason Lexon that you've heard testify. Obviously, he wasn't very credible. No matter what, there was something going on between Isaiah Orozco stood there discussing with him. He didn't pull out a gun when he was discussing anything with him, but when 6 foot, 255-pound man gets up and starts advancing towards him at 5'3", maybe soaking wet, 130 pounds, Isaiah backs up, pulls the gun. What does the defendant do? He stopped. He sees the gun. That's reasonable. You see a gun, you're going to stop. He's going to stop advancing towards. What does Isaiah Orozco do then? After he stops advancing, he puts the gun back in his pocket. He stands there. He gives this signal. You can take for that what you believe that means. And then he points the opposite direction. He decides to turn around. So, self-defense. Isaiah Orozco could use self-defense on himself, for himself, just as this man can. I can. Was Isaiah Orozco reasonable then? He believed he was being advanced upon by a superior individual physically. But he believed possibly that his life was in danger. More serious violation.
Fact in the law.
All right, ladies and gentlemen, you will remember the witness's testimony as you heard it. And with regards to the law will be given to you in the charge of the court.
So you just remember that. But no matter what, he puts that gun back in his pocket and decides to turn the other cheek and walk away. And one person decided to pull out their weapon and use it. And it's that man sitting over there claiming self-defense. So when we talk about self-defense, as in board ire, you saw these charts that I gave you earlier last week. Remember, I highlighted reasonably believe that the force is immediately necessary. You tell me the force is immediately necessary when I have my back towards you and I'm walking away. Same thing, deadly force. To use deadly force, what are those highlighted words again? Reasonably believes, immediately necessary. Again, my back is towards you, I don't have a weapon in my hand, and I'm walking away. Reasonable belief, it's in the definitions, it's in there. But an ordinary, prudent man in the same circumstances I could have reasonably believe that it's immediately necessary to shoot a man 15 times, or rather, shoot at him 16 times. Remember this from the board ire that I gave you in front of you. Not a future threat. Not that, hey, he's going to come back and shoot you. Must be immediately necessary. Can't be words alone, as a defendant testified to that when he was walking off, he was saying words. I couldn't hear what he was saying, but it was saying stuff. I inform you that Isaiah Orozco was abandoning this situation. He turned around and left. He was done. This was not a reasonable reaction by the defendant. It was not a de-escalation. It was an escalation. So self-defense, especially deadly force, should be a last resort. Use your common sense here. This is common sense, and it's not a classic case of self-defense. Isaiah turns his back and walks away from the defendant. You'll see where they're standing. This is from the video. You see where Isaiah is turning around, and you see the defendant standing off by his buddy, Jason. You'll see Isaiah walking away. He takes 7 to 8 steps. 7 to 8 steps. That's 1, 2, 3, 5, 7, almost 8 before this man opens fire on his back. 7 to 8 steps as he's walking away. Classic self-defense as defense counsel. Defendant chasing down Isaiah. This is where he begins to run. He begins to run after Isaiah. Isaiah's back is still to him. Still, he continues to chase Isaiah until he falls. And maybe he should stop there, but he decides not to. He advances one more time. Those pauses in the shot, that 15th shot to the 16th shot, there's a pause. You can hear it on the video. He walks up to him and shoots him in the head. Although, defendant testified that that was an accident. He didn't mean the last shot. Just happens to hit him square in the head, right in the middle. You saw the picture of Isaiah's head. Pretty good accidental shot. It's not an accident. He chose to take this man's life. He chose to be the individual that decided whether that man lived or died, because for any other reason other than the defendant, Isaiah displayed a weapon towards him, put it back in his pocket, and turned it back. This time, I'll tell you this. Defense of himself, absolutely not. Absolutely. Defense of the third person, I don't even know why I need to address it, but I will since it's in the charge. Absolutely not. Mr. Isaiah Orozco didn't display that gun to anybody else other than the defendant, because the defendant was advancing upon inferior physical individual towards. Mr. Isaiah Orozco did the right thing. He put the gun back in his pocket and turned the other cheek into his neck, because he took the high road. Now maybe having a weapon, you've heard he had this weapon from an artist gun club that legally, as he's walking away, this individual with his firearm takes the low road. Says, not today, I'm going to take you out. And he does that exact thing. What I can tell you is don't make this so. Don't make this so. Shooting somebody 16 times. Use your common sense, and I implore you that this is a guilty of murder.
All right, ladies and gentlemen, you've heard all the evidence that you've heard in this case. Each time I keep telling you, I'll let you know when it's to deliberate. So you're going to be taken to the back where you can select your foreperson, and then you can begin your deliberations. If I can have Mr. Gallegos, if you would remain in the box, please. And everyone else, Deputy Moore will take you to the jury room. Everyone, please slide. Right, if I can see defensive state, please. Oh, everyone, please still stay. So if I can sign the court not released it, and in which case they'll start.